Hello students, welcome to EPG Patashala. I am Dr. K.R. Ramamohan, Associate Professor, Head Department of Anthropology, Sikkim University. Today we are going to discuss a module on National Commission and Committees on Development and Welfare of Scheduled Areas, Tribal Areas, with reference to scheduled tribes. This module comes under paper Indian Anthropology. So before we go this module, let us see what are the learning objectives. Through this module, we will able to know the National Commission, the Committees on Development of Welfare of Scheduled Areas and Tribal Areas. To know about the National Commission, with specific reference to scheduled tribes in India, to know more about constitutional provisions administered for the development of scheduled or tribal areas, and to know how this administration of welfare schemes for the scheduled tribes. To begin with, we need to have more understanding and gain more insights into where the Constitution of India provides for uniform rule for the entire country. However, certain regions of the country are governed by certain special provisions, and these provisions ensure only to protect the cultural identities, the prevailing customs, the economic and political interests of the traditional original inhabitants of these areas. If we go to certain parts of northeastern India or North India or South India, we come to know in tribal areas that these areas comes under certain special provisions. Because the only fact is that we need to recognize that there are scheduled tribes residing in this area, and these provisions are meant for them, where these provisions are not a part of the other non-tribal communities. So these regions include the tribal hills of northeastern states, Assam, Arunachal Pradesh, Manipur, Nagaland, Mizoram, Meghalaya, and Tripura. And even in the state of Jammu and Kashmir, we can see that there are certain scheduled areas where scheduled tribes are there, and they require special attention. So the scheduled areas are those tribal inhabited areas predominantly which are located in other parts of the country as well as in northeastern India. And these are areas are also being seen in South India like Andhra Pradesh, in Central India like Bihar, Chhattisgarh, Western India of Gujarat, Northern India of Himachal Pradesh, Madhya Pradesh, Jharkhand, Maharashtra, Orissa, Rajasthan. And there are also other regions in the country, for example like Andaman Nicobar Islands, Lakshadweep also has significant tribal population, where these special provisions are being put in place. So let us look into the specific safeguards provided for these scheduled tribes. One of the important article in the Constitution, article number 244, clause 1 says that the provisions of the 5th schedule shall apply to the all administration and control of the scheduled areas and scheduled tribes in any state other than the states of Assam, Meghalaya, Mizoram and Tripura. So according to class 2, the provisions of the 6th schedule shall apply to the administration of the tribal areas, the states of Assam, Meghalaya, Mizoram and Tripura. So in the sense, the first provision to Article 275 in class 1, the Constitution of India guarantees grants from the Consolidated Fund of India each year for promoting the welfare of scheduled tribes and in pursuance of the constitutional obligation, where specifically the Ministry of Tribal Welfare, which is constituted to look after all the tribal affairs, provides funds through this central sector scheme, grants under Article 275 clause 1 of the Constitution. So the objective of the scheme is to meet the cost of such projects for the overall tribal development as may be taken in each state governments, for raising the level of administration of scheduled areas, therein of the rest of the state. So the scheme covers all the 21 tribal subplan states and 4 tribal majority states of the country. So in accordance with that, the 5th schedule contains provisions regarding the administration and control of scheduled areas, where most of the communities are scheduled tribes. So there are 9 states having scheduled areas: Andhra Pradesh, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Orissa, Rajasthan, Chhattisgarh and Jharkhand. And the governors of these states have special responsibilities and powers, where the states have tribal advisory councils, or called TACs, where they give specific inputs for the development of tribes and in what areas the tribes should be developed. The councils are formed on these lines. Again, the 6th schedule contains the provisions relating to administration of the tribal areas in the states of Assam, specifically the North Kachar Hill district, Karbi Anglong district, Meghalaya, Mizoram and Tripura, which they have autonomous hill districts. And there are autonomous district councils and autonomous regional councils in these areas, which have a long tradition of self-management system. So they did not fall under the overall administrative pattern. They have their own councils. So these autonomous councils not only administer the various departments and developmental programs, but they also had powers to make laws on variety of subjects. Example, on the land, the forests, neighboring forests, issues relating to shifting cultivation, village administration, to some extent the social control like police, public health and sanitation, taking care of how the inheritance of property rights and disputes relating to marriage in terms of divorce and any other issues, violation of the traditional norms, where they used to cater all these and try to settle these disputes. So the 6th schedule of this Constitution India created for autonomous districts within Assam in order to preserve tribal autonomy and protect the cultural and economic interest of these tribes, which are predominantly residing in the hills. Hence, the hill regions of northeastern India have a history of being governed by different criterion in comparison with the rest of India. Whereas if you look at a comparison, the tribes in central India, the tribes in South India, the tribes in North India, and the tribes in northeastern India, because of these hill councils, which are autonomous in nature, are slightly different. So coming to the concept of tribal areas, the tribal areas in the states of Assam, Meghalaya and Tripura and Mizoram are separately dealt with, and provisions are laid for their own administration, which are specifically found in the 6th schedule of the Indian Constitution. So part 10 of the Constitution is concerned with this administration of scheduled areas and tribal areas. So how to say that this is a scheduled area that is being enshrined in the Indian Constitution because of the predominant tribal population. So the Constitution makers thought for the special provision for this administration, specifically the scheduled areas, presumably because of the backwardness of the people in these areas, be it in terms of economy, land holding, and other social criteria which make them backward compared to other areas. So subject to the legislation of the Indian Parliament, the power to declare an area as a scheduled area is given to the President, and President himself can only name the scheduled areas order according to 1950 order. So the tribal areas in the states of Assam, Meghalaya and Mizoram are being separately dealt in the 6th schedule of the Constitution. Now, being understood this, how does this system of administration goes about? So the 5th schedule of the Constitution deals specifically with the administration and the control of scheduled areas as well as scheduled tribes in these states other than Assam, Meghalaya and Tripura. The main features are: the executive power of the Union shall extend to giving directions to the separate respective states regarding how to do administration of these scheduled areas. So each governor of each state in which there are scheduled areas have to submit a report from time to time to the President regarding how the administration is going on in these scheduled areas. Whenever the President requires. So tribes or the tribal advisory councils ought to be constituted specifically to see and to get advice on such matters, because they are the people who give all the inputs at the grassroots level for their welfare and for their advancement of these backward scheduled tribes. So the governor is authorized to direct that any particular act of parliament or of the legislature of the state shall not apply to scheduled areas only, because subject to the expectations or modifications, the governor is also authorized to make regulations to prohibit or restrict the transfer of land among the members of scheduled tribes. So these provisions of the Constitution relating to the administration of the scheduled areas and the tribes may be altered by Parliament or by ordinary legislation. Hence, the Constitution provides for the appointment of a commission to report to why the administration is, how the administration is going on in the scheduled areas, because they are taking care of the welfare of the scheduled tribes. Hence, The president have all the powers to see what is happening, which was been in the culmination of a, a commission which has been set up by Sri Jabbar, which is also called the Jabbar Commission, which appointed in 1961. So the tribal areas to be administered as autonomous districts. These autonomous districts are not outside the executive authority by the government of Assam, where the councils are primary representative bodies, which gives a lot of inputs on the management of forests, inheritance of property laws, marriage, customs, and any other social unrest has taken place within the community will take care of these councils. Let us understand how the formation of an autonomous state comprising certain tribal areas. So according to Article 244 of the Constitution, the 6th schedule lays down special provisions for the protection of the interest and the cultural identities, particularly the hill tribes of the north. So the most important provision of the 6th schedule is the creation of autonomous district councils, which are very specific in this area. So while the tribes, some of the northeastern states have the autonomous district councils, the Arunachal Pradesh, Nagaland, and Greater Mizoram do not have this autonomous district councils because the inner line regulations exist for these three states, especially Arunachal Pradesh, Mizoram, and Nagaland, and North Kachar district of Assam. Now there were several amendments to the Scheduled Tribes panel in terms of protection from non-tribals' rights past. So under the aegis of the Lok Sabha, it has unanimously passed two constituent amendment bills. The first bill empowers the government to set up separate National Commission for the Scheduled Tribes, which looks after the problems and issues of the Scheduled Tribes, while the second bill seeks to protect the rights of the non-tribal in the newly elected Bodo Territorial Council, or what you call BTC in Assam. So the Lok Sabha passed the constitution where it is called as the 89th Amendment Act in 2003, making provision for the setting up of National Commission for the Scheduled Tribes, and another to keep intact the existing representation of both tribes and non-tribals in the Assam's Legislative Assembly. So the amendment focuses on the need for setting up separate commission for the Scheduled Tribes by bifurcating the existing National Commission for the Scheduled Castes. Earlier it was National Commission for Scheduled Castes and Scheduled Tribes, but now there are two National Commissions which specifically looks for Scheduled Castes, which specifically looks for Scheduled Tribes. So the 99th Amendment, which has been an addition, seeks to protect the rights of the non-tribals, particularly in the Bodo Territorial Council. And the proposed commission for the scheduled tribes would comprise a chairperson and two other members, and the National Commission for Scheduled Castes shall have chairperson, vice chairperson, and three other members. So, notwithstanding anything in this constitution, Parliament may, by law, form within the state to Assam an autonomous state comprising, whether wholly or in part, all the tribal areas of 6th schedule and create thereof, which specifically is there in Article 244A, which states that a body, whether elected or partly nominated, to function as a legislature for the autonomous state. Hence, a council of ministers, which constitutes both the powers and function in each case, which is specified in the law. So, any such law is referred to clause 1, may in particular specifies the matters enumerated in the state list or in the concurrent list with respect to the legislature of the autonomous states. It also defines the matters with respect to which the executive power at the autonomous state shall extend. It also provides that any tax levied by the state of Assam shall be assigned to the autonomous state insofar as the proceed thereof attributable to autonomous state. Make such supplemental, incidental and consequential provisions as may be deemed necessary. So, an amendment of any such law has been discussed now, insofar as such amendment refers to any other matter shall have no effect unless the amendment is passed in the House of Parliament. So, the modern institutions of these autonomous district councils are the elected bodies. So, they are controlled by new generation, which has benefited from the higher education in the modern context. So, this placed the new elite confrontation with the traditional elite, who have considered it as an encroachment on their position. In fact, they have been demanding it as an abrogation. Also, a section of the non-tribals have been seeking the removal of these autonomous district councils. So, hence there is some kind of difference in this opinion whether to have this autonomous district councils. They say that the 6th schedule has introduced to protect the interest of the tribals, while they would be constituents of Assam. But with the formation of these separate states, there was no need for these autonomous district councils, where the state legislative and the village councils are approaching the jurisdiction in different ways. And this is causing inconvenience for the population, where the age-old legislation given by the British colonial administrators, the system of inner line is drawn up under the Bengal Eastern Frontier Regulation way back in 1873. So, this is prohibiting the travel of outsiders into the area beyond the inner line without the government's permission. And this is how there is a problem, primarily the exploitation by the plainsmen, where the British has given the way. So the inner line has become a subject of hot controversy in the Northeast India. With this, the Constitution in its 90th Amendment Act in 2003 has ensured a fair representation of the non-tribal in the Legislative Assembly, particularly in the Bodoland Territorial. So with this Article 338A, National Commission for Scheduled Tribes, clearly states that there shall be a commission for the Scheduled Tribes, to known as National Commission of the Scheduled Tribes now onwards. It is subject to the provisions of any law made in this behalf by the Parliament, and the commission shall consist of a chairperson, vice chairperson, 3 members, shall act such as president may be when the rule determines. Hence, the chairperson and vice president and other members be appointed by the president by warrant under his hand and seal. Hence, the commission shall have the power to regulate its own procedures. So, it shall have the duty of the commission primarily to investigate and monitor all matters which are relating to the safeguards provided for the scheduled tribes under the Constitution or any other law by the time of being in force or under any order of the government to evaluate the working of such safeguards. Further, it is also there to look and inquire into specific complaints with respect to the deprivation of the rights and safeguard all the scheduled tribes. Hence, to participate and advise on the planning process of socio-economic development of scheduled tribes and to evaluate this progress of the development under the union or any other state. To present to the president annually at the end of such other times or whenever the commission may deem fit reports on how this is being safeguarded and make these recommendations for effective implementation in protecting their rights, in development of socio-economic aspects of these scheduled tribes, and to discharge such other functions in relation to their protection, welfare, development, advancement of all the scheduled tribes, as the president may subject to provisions of any law made by the Parliament. So, the president shall cause all such reports to be laid before each house of the Parliament, along with the memorandum explaining the action taken or proposed to be taken on the recommendations relating to the union and reasons for the non-acceptance, if any is there, basing on such recommendations. Again, if any such report or part thereof relates to any matter which has been forwarded to the governor of the state, shall be laid before the legislature, and to seek explanation on the recommendations relating to the state and reasons for non-acceptance, if there is any such recommendations. Hence, the commission shall, while investigating any matter, refer to the subclasses or inquiring into any complaint referred to as subclass B, have all the powers to civil court trying to set suit. Hence, summoning, requiring the discovery, re-questioning the public record, issuing commissions for the examination of the witness and document, or any other matter which the president may by rule determine. So the union and every state government shall consult the commission whether to take any major policy matters which directly or indirectly affects the scheduled tribes. Being understood all the clauses and subclauses and the functioning of how the commissions have set up, the functions of these commissions, and the reports submitted and the decisions made taken by these commissions need to be understood in the light of how the scheduled tribes' rights are protected and the specific problems faced by the scheduled tribes, and what are the alternatives being given attention for the socio-economic development of the tribes. So it is important that we understood the 5th schedule, the 6th schedule, and the states which come under the 5th schedule, the states which come under the 6th schedule. What makes this concept of scheduled areas? Why there are special autonomous hill councils? What are the rules and regulations of these autonomous hill councils? And what are the issues which are permitted? How the autonomous hill councils are in place with the state government legislations? What kind of issues have come up? And how the new generation is taking up these autonomous hill councils in the areas of 6th schedule, which specifically talks that these scheduled tribes need special attention when compared to the other scheduled tribes in the rest of India. So to look after these things, the central government has put up a commission to see how it has been functioning, and time to time the president is interested to get these reports from the respective states through governors, whether to recommend or to alter new policies and programs for the welfare of the scheduled tribes, aiming for their empowerment process. Thus, it is important for us to conceptualize the whole concept of scheduled tribe areas administration, the formation of these councils, the functions of these councils, and how these councils are making periodic suggestions in tune with the concerned state government's recommendations, with a special interest to protect the tribal culture, to protect their individual rights, their rights over lands, and their well-being.